Welcome, everyone. Welcome. I'm really delighted everyone's been able to join us today because I think we've got a really good subject and a fantastic presenter talking today. So obviously we're here to talk about challenging social injustice in adults' health and social care services. On our key speaker today, now I'm going to do my best to pronounce well, but it's let me have a go at this. It is Belinda Square. I've got that wrong, haven't I, already, Belinda? So I do apologise. But Belinda is going to be obviously our main speaker today. But before I introduce and talk a little bit about Belinda, I just need to do some housekeeping duties. So can I ask people please to introduce themselves on the chat so we can understand who is here? Can I ask you also to stay on mute when not talking? You can leave your cameras on if you like, but particularly good to have them on when you're asking a question. But I am going to say we are recording this session, so just to let you know. And I think that's all the housekeeping things we need to say at this stage. Yes, that's not missed anything. Good. Now, Belinda is going to see as our main speaker today, and at the end of that, obviously, there will be opportunity to ask lots of questions. So I hope people have got lots of questions. Do put them in the chat. But it's not really a session intended for asking detailed situation-based questions about law and rights. But I do know that Belinda's organisation have got a considerable amount of questions and answers available, which I think covered a huge amount of points that are very valid. So even if you haven't got the questions, I do urge you to look at the website and look at other information that Belinda's organisation, Cascade, have put together. So I am going to now introduce you to Belinda and give a little bit of talk about who Belinda is and experience. And well, Belinda was practiced as a barrister, then taught public law at university law schools, then returned to professional practice, re-qualifying as a solicitor in 1998. And Belinda developed a specialist practice in adult social services, mental capacity, health, care law, and human rights. And her experience as a public speaker dates from this period. She began to offer training courses as a complementary addition to her litigation practice. Now, Belinda spent the last 20 years appearing at national conferences in England, Scotland, and Wales, and running many face-to-face training and consultancy through her business care and health law. Now, prior to setting up the development of Cascade, Belinda supervised a nationwide team of specialist trainers who provided over 500 days of face-to-face training to 40 councils on the Care Act in 2015. And Belinda's advised many LGOs and ADAS and NAS and charitable and private sector care home providers, domiciliary care and support providers, CCGs, special schools, service users and carers. So considerable experience. And she created the Care Act checklist, which provides the main scaffold of the free scope advice service offered by Cascade. So now I want to hand over to Belinda to give her presentation. As I say, please do put your questions on the chat. We do want this to be as interactive and as valuable for all as we possibly can. So Belinda, let me hand over to yourself.
Good morning, everybody. Thank you for that introduction, Alan. You didn't do a bad job on the name Schwer.
Rubbish. It was rubbish. Sorry about that.
It's easy because it actually rhymes with Schwer, you see. Sorry, care. So Schwer and care go together. That's the way we're going to do it. I've been asked this morning to do, I think, a challenging talk because anyone who's had my training knows that I don't hold back. I have to say that training for the Care Act across the country and then realizing that austerity was going to mean that it wasn't going to be properly funded, so that those 500 days of training were probably a complete waste of time. And then realizing that austerity meant that no more training would ever be booked again after the bums had been put on the seats and the boxes had been ticked. And then having to deal with everybody going mad over Brexit, and then everybody going mad over COVID, whilst I'm trying to set up a charity to do something nobody's ever done before, has made me somewhat cynical and probably less sparkly than I used to be, but that's my lockdown mode. So forgive me if I come across as just astonished and outraged at what is going on in local authority land. The talk today is going to be about the general state of regard for the rule of law, or the state that we're in whereby most councils are not complying with the legal framework, and the particular challenges that COVID seems to be adding to the mix, so that the voluntary sector has got bite-sized routes into getting more legally literate. And the whole purpose of this, although we're going to end in an upbeat way, I hope, with Alan taking us to see the way forward, I have to say that the provocative part of this talk is going to be how we have dumbed down in adult social care so that we do not value knowledge any longer. We just value skills. We value being person-centered. We value being a good listener. We value persuasiveness in terms of advocacy. My point is that without knowledge of the legal framework, which is difficult, but which is not rocket science, all of that skills focus ends up with a very thin and aerified means, a toolkit with which to help people enforce their rights. So I'm always going on about legal literacy, and you might well say, well, of course she would. She makes her living from it. But at this moment, I make my living from giving lots and lots and lots of free advice. And the standard of the legal knowledge of brokers, advocates, and peer support groups is just painfully low. So I'm promising you that it's going to get better. But I have to say, I think that the culture of people learning anything from reading on their own has practically gone out the window. And I think that if we're allowing for that in the voluntary sector because we can't pay for anything better, just think about what the effect of that is in the statutory social work sector. You have to be worried if your social worker doesn't know the legal framework. For goodness sake, they are a public officer and they are a professional. So I think it's going to be a punchy talk, and I hope that people enjoy it. I needn't tell anybody in the voluntary sector what the problem is. It's, of course, money and austerity and the last 15 years worth of budget cutting. But the real problem is that adult social care law is in legislation that was designed to be able to ebb and flow. It turns on discretion and judgment on waffly principles such as sufficiency, necessity, and timeliness. All of these things that COVID has managed to expose the real width of, because after all, when do you say that something is unconscionably delayed any longer when we're all working through wading and through treacle, and we all have human empathy for the social workers who do the job? Everyone knows that within the last 10 years, the idea of being reviewed probably struck fear into the hearts of social services users, because a review, instead of being a good thing, came to be equivalent to a notification that there was bound to be a cut. And throughout this whole period, legal aid has been getting harder, not just harder to get, it still exists in community care law, but harder to make a living from. And once something in this country becomes hard to make a living from, the expertise evaporates, because nobody can afford, after studying law, not to see some money coming back the other way. So advice centres shut, and the people who had community care legal expertise, they waft off to doing something else. We are finding at the moment that even trying to run Cascader, it's almost impossible to find people with relevant legal acumen. Everybody is supposed to know the Care Act, but actually applying the Care Act is a very different thing. So that's what's interesting to me, and one of the challenges that I hadn't quite expected to be so difficult. Now, the good thing is that there's always been judicial review, and judicial review has carried on despite the Care Act having wiped out 15 previous years of litigation that had established principles of some real importance for disabled people and chronically ill people. So there've only been about 12 or 15 cases that are worth anything in the last 5 years. But you can have a case list with all of those really important ones on it, and you can spread that around. And what people love about the cases is that they're about human stories. So you don't need to be a lawyer to enjoy reading a case. Judges always saying lyrical things, and people love to know who's won and who's lost and who has been hammered by the judge in terms of criticism of their professionalism. We have that side to us, don't we? The point is that not only has the case law been now busy re-establishing most of the principles that had existed before 2015, but the local government ombudsman has got completely fed up with local authorities, including Norfolk, breaching the Care Act. Those of you will remember the Equal Lives attempt to get Norfolk told off by CQC, and then ultimately there being a bit of a compromise with a sky audit of Norfolk in the year after the Care Act had been introduced. And in those days, the auditor was extremely polite about Norfolk and nothing really came of it. But the local government ombudsman is now so fed up with upholding 68% of adult social care complaints that the LGO is following the new case law and cheerfully saying that's a breach of the Care Act or that's non-compliant. Not that this is an opportunity to learn how to do better, but this is frankly against the law. So I'm excited about the legal framework, but I can understand why other people are not. I would say all we need to remember is that there are 4 principles of public law that really provide the bedrock. Public bodies in everything they do have to act rationally, lawfully, fairly, and compliantly with human rights. And the knack is knowing what those concepts mean. It's also important to have a local population that doesn't just take what it is given. People who are vulnerable and dependent, even if they are well educated, let alone if they are not, can tend not to wish to bite the hand that cares for them. And the voluntary sector needs not to fall in with that culture just because the voluntary sector is being grant funded by public bodies. Now, in the last 8-9 months, these are the specific COVID challenges that we have seen developing as trends. All councils rationing assessment and prioritising the meeting of needs instead of actually meeting them, but without adopting the easements. The easements would have provided all councils with cover. 8 councils decided to adopt and then they left off of adopting. And now it almost seems to be ADAS's edict that no council goes anywhere near edicts ever again. But the reality of that is that they're all supposedly acting under the Care Act as it was first written, even though it is in fact legally suspended. And therefore there shouldn't be a concept of rationing and prioritising at various stages of the Care Act. It should still be meeting needs and not just meeting needs as best we can. Obviously, there's greater reliance on informal care because people are at home and they are legitimately scared for their chronically ill relatives. But this is being done without welfare calls or formal reviews or revisions. Around the country, there's a lot of shenanigans going on regarding day services closing, even though they do not need to be shut. And then you find out that, in fact, the council has negotiated closure by basically threatening to tell its own clients not to go to daycare. So there's lots of language difficulties around who is doing what to whom. In particular, I'm concerned about supported living providers behaving as if they were running care homes regarding the management of the environment on the assumption that the Mental Capacity Act allows them to tell people who have a tenancy in their own home how to live and how or whether to abide by lockdown rules. And then, of course, there are the infamous blanket refusals to permit face-to-face assessments by staff or BIA or advocacy services to run in anything like a feasibly adequate way, and of course all the rules against visiting. So all of these issues reside in the legal framework, and there is an answer, or at least a moot point, a debatable answer to all of them. What people need to understand, and I won't spend long on this slide, is that there is in the Care Act, even though everybody is doing it holistically and as quickly as possible, there is a linear route through the Care Act with a stage followed by another stage, followed by another stage, and due process rights that apply after every stage, in the interests of accountability and transparency. But it's no use if nobody knows what those are or what those mean. And we are all assuming that 3 conversations is equivalent to a Care Act assessment. I don't know if Norfolk is using the 3 conversations, but I know that Norfolk is doing a lot of other things that clients come to me and Cascada about, and we have to engage with those. So all I'm pointing out is that there is a linear process through the Care Act with legal rights at every stage, and that they are valuable. One of the interesting things about the guidance is that it adds to the fairness of the Care Act, and it actually says people should have advance notice of what assessment is all about. So knowing that would mean that the voluntary sector could prod and remind people, to remind councils, particularly Norfolk, and advocates could agitate for advance notice and person-centeredness around the timing, location, and manner of the assessment. Not maybe during COVID, not so much, but at least knowing the guidance helps you put flesh on the bones. I'm sure people know that the Care Act brought in formal, funded, independent Care Act advocacy rights. And within a very short while, there was a case involving Haringey in which Haringey was caught out for not bothering to organise formal advocacy, not generic advocacy, but formal Care Act advocacy for a woman who was in a really dire state and who couldn't possibly be expected to understand what was going on. They tried to argue with the judge that running out of supply was a good excuse for not doing advocacy appointment. And the judge just choked and said, "I know the law of statutory duties, thank you very much. This duty is not one where shortage of financial resources or commissioning ineptitude is a legal excuse for not discharging the duty. In other words, it's where the council's reserves in the dungeon downstairs would be the relevant thing to look to." So there's all sorts of good stuff in the legal framework about supporting a person's involvement in assessment. Obviously, I'm talking about the person who's at the subject of the assessment, at the heart of the assessment, the service user or applicant. But look how clear the guidance is. And there's no consent condition here. In the case of an adult with needs, the local authority must also involve any carer that the person has. And in all cases, the authority must involve any other person requested. So the easiest way to get any local authority thinking is to say to them quite openly, "Give us your definition of involvement, please. Do not tell us that it is as short or as long as a piece of string and depends on whether we like the family's relatives. Tell us what you think involvement means. It's been left vague for the purpose of you telling us, but subject to public law." Involvement could not mean, for instance, just telling a carer afterwards what had been decided. The concept of involvement includes the concept of influencing the decision that is being made. Every time the guidance says must, it's because there is a section or a regulation that the guidance authors have referred back to. And there you can see in section 9.5 is the corroborative duty to in the legislation to consult, to involve any carer that the adult has. And my point about this is that this is without regard to mental capacity. We have the MCA concept of consulting best interests consultees when a person is in an MCA context and needs there to be a best interest decision. But here, this is without regard to incapacity. And this means that capacitated people can insist on their current or their preferred provider being involved in their assessment. And that is a fantastic right. It includes a private advocate, but of course it doesn't mean that one will be paid for. So everybody gets Care Act advocacy, whether or not the Care Act advocate knows anything about the Care Act and knows what legal rights and duties are all about. Now, this is a slide that will be of relevance to people to study afterwards, but people assume that because there's a right to be involved for a carer, there must also be a right to see somebody else's care plan. And that is actually not the case. The rights to see somebody else's care plan, past or present or emergent, depend on the service user's consent to the carer being shown it. And then incapacity puts another layer on that. So that's really important that people understand that where a right to a bit of paper is contested, then you are talking about confidentiality, GDPR, and the more nuanced approach to actually disclosing sensitive personal data. Being involved does not mean being present, and being involved does not mean having a right to look at the bits of paper. This is more guidance on a further duty to involve the carer at the stage of doing the care plan, working out the care plan. But some of the most valuable information in the guidance is highlighted there in yellow. Provided the carer remains willing and able to continue caring, the local authority is not required to meet the needs. The needs will have been found to be eligible. An indicative budget based on the unmet needs will have been identified if a council is still using indicative budgets. But at the duty to meet needs stage, if the carer remains willing and able, and not just manipulated into being willing and able, the local authority is not required to meet the needs. The guidance is there for anybody to use. The local authority should record the carer's willingness to provide the care and the extent of it in the plan. And the idea is that once that's done, at least the carer knows what is being assumed of them if that's the way your local authority has been working. There are some slides here about what the system does for carers. And in particular, we're talking about not needing to be doing regular and substantial amounts of care in order to be deserving of that title. And we're talking about how, in the end, there is no human right to carry on caring at the cost of the state. You have to make a choice as a carer, and choosing to withdraw all or some of your care does inevitably affect the lifestyle and the extent of choices that your loved one will be given, because public authorities can take cost of doing some of what you used to do for your loved one into account. And people need to understand that this is a legal truth, and it is not meant to be a tool for threatening carers or a tool for manipulating them, never into giving up. I had a client this week who is a carer. She was arrested for assaulting her elderly mother in an incident of carer strain. She has schizophrenia and cancer herself, and she was arrested for assaulting a police officer who magically came along with the ambulance because she is on a list somewhere of people who may behave strangely. This slide about carers is all about their decision-making rights that arise or do not arise by virtue of the role that they have taken on. And we think that that would be extremely useful for people. And this slide about, does a carer have a right to stop caring if they want to work? I want your voluntary sector to put lead in people's pencils by being straight with them about some of the really difficult moral and ethical choices that need to be made. I would prefer it that social workers told them the truth, but if social workers can't or won't, then the voluntary sector has to do that. This is a really important leading case that came out last October. And all I want to tell you about it is that it's the most important case since the Gloucestershire decision. And it gives individual human beings a right to something that they have never had in the Care Act legal framework. It gives them a right to restitution, financial money back again, if a council is found to be in breach of the Care Act. So supposing Norfolk thinks it's a good idea to take on a new interim management consultant and pay them a lot of money to manage more millions out of the budget. If the way the manager chooses to do that is a breach of the Care Act, and there's a judicial review about that, then that individual and all the others affected by it would need to be paid back what the council had thereby thought that it had saved by paying the expensive management consultant a lot of money. It's not damages for harm, it is restitution of an individual's financial position if they have gone without and as a result have had to rely on somebody else who was not just doing it for love, or have had to spend their own money. They are then entitled to make Norfolk disgorge the unjust enrichment constituted by acting in breach of the Care Act. And if this wasn't COVID, I would be in court every day arguing this. I think that probably the nation is owed about £150 million back in a repayment exercise as a result of this case. And so CP in North East Lincolnshire, not so very far from you, very cheering for a service user, and Lord Justice Haddon Cave should go to the top of the class as far as I am concerned. These are some slides just to show you from the guidance about how the guidance broadens the bald words of the regulations. So if Norfolk says we don't do shopping or we don't do cleaning, then the answer is to look at the guidance and not just the bald words of the eligibility domains. The guidance says managing and maintaining nutrition includes considering whether the adult has access to food and drink to maintain nutrition. And that is how the local government ombudsman has derived as a principle that it is simply not legal for a local authority to announce that it does not do shopping or it does not do cleaning. Transport is more tricky, but again, a blanket idea that we don't do that is unlawful. And that's why the Ombudsman is so busy, because all councils are doing it. These three slides here are honestly all you ever need to know about the principles in this country about when is there a duty to meet need. So first of all, we set out the general position and we talk about how resources are allowed to be relevant to the question of how generous a council is. Then we go on to looking at the broader legal principles that effectively shore up community care law in its pure essence. And then we look at the relevance of anyone's dissent or disagreement to a care plan. 3 slides on care planning law is all anybody needs, in my view. And I don't expect you to believe me, but I would expect you to be game to learn. This is the most important slide in the guidance. It explains how a local authority is bound to meet individuals' needs properly and appropriately, but also must not run out of money for all of its other functions. And it has been clearly written by an individual who knows what they're talking about. And it is disingenuous as well as legally accurate. It says the council should not set arbitrary upper limits on the costs it is willing to pay to meet needs through certain routes, i.e. cost capping of home care. But it doesn't spell that out in words that would make sense to people who didn't know what they don't know about what all local authorities are doing. And therefore that is my grouse effectively with the guidance. It is accurate in 99% of its presentation of the law, but it is not accessible and it is not referenced with the cases. This is the second most important slide in the guidance. What to do when, despite a council theoretically taking all reasonable steps to agree a care plan, you ain't agreeing it. And this is an example of how disingenuous the guidance is. It says that council should recommend that people complain after doing a management review, at least to see where they've cocked up. But in fact, it does not mention judicial review, and it does not mention a remedy called going to the monitoring officer. So you can see from my perspective why I think that this guidance has been sweated over to be accurate without being helpful. Many people are in dispute with their councils about the size of their budget, their final budget. So I have put up some slides from the guidance about how it should be sufficient, how it should be transparent, and how it should be vitally evidence-based. And people must be choking when they read that. Number one, because it's there in the guidance and available for everybody to see, but not used in practice. When did you last see a social worker getting the guidance out? And secondly, because actually you can see that these words are woolly. Sufficient, transparent, and rational and evidenced is all really down to the culture. And I personally think, from what I've seen of it, that the culture in Norfolk is hierarchical and top down. And that worries me when I have clients who come from that culture. You may think that I don't believe that the Care Act is about choice at all. And you'd be nearly right, because I have set myself the exercise of working out then where in the Care Act there are actual rights to choose. And there is no right to co-production. There is no right to supported self-assessment. There is no right to a direct payment. But there is every chance of a clued up voluntary sector being astute to make it as difficult as possible for any local authority to say no to people if they assert their wishes to have these things. I promise you. This is just one slide that gets me into COVID in particular, just to be really controversial. I'm sure we all know that the whole of the supported living sector operates on the basis that it has to bid lower and lower and lower to get on the framework, dumb down its staff, pretend that it's not doing anything more than prompting, not doing prompting and supervision, but just doing prompting so as to avoid having to have registered care workers, and fundamentally offering shared care at night, now creeping into shared care in the afternoon and shared care in the morning, so that everybody has to go to a medical appointment with everybody else. Banning, apart from COVID, people would have to go to the same church, etc. It turns out that for 5 years, it's been the law in the Care Act that a local authority can only make you share a budget if every single adult affected by all of the proposals agrees. And with 14,000 people with learning disabilities in supported living, and only some of them having capacity, you do have to wonder how their agreement has been properly obtained. Is anybody using section 2511? Cascader is, even if it involves bringing down the market so that supported living is redesigned and re-envisioned to involve proper agreements for sharing when it actually suits people and not when it just suits providers and not when it suits commissioners. So I think that that will be an interesting example of why I think more knowledge is needed. The last few slides are about revisions. And there's a great myth, I think, out there that people's care plans can be revised only if there is a change in the client's needs. The law does not say that. The law says that the local authority can plan to revise a budget when there has been some other change of circumstances that affects the plan, like a price drop, for instance, not that there would be one at this moment. But in a few weeks' time, when furlough is well and truly over, and people have got nothing to do because they've been made redundant, we could see the price of social care staff drop through the floor. And on that basis, you will be finding that councils will be going mad in terms of revising people's budgets and revising people's care plans. If you don't know the law of revision as opposed to the law of review, you don't have a big enough knowledge base, in my view, and it is the most important thing that anybody could pass on to the client. Here's an example. This is section 27. Section 27 distinguishes between review and revisions. People think that there's advocacy for review, but in fact, there really is only advocacy for revisions. Of course, if people are doing reviews and then immediately revising the care plan because they'd already made a decision to before they came out to do the review, an advocate should be there. Because if it's all going to be done as one, then the right to an advocate for a revision process is a mandatory legal right, which invalidates the whole new plan if the advocate wasn't there. And here are the most important rules in section 27 about going back to do a proportionate reassessment, without which there cannot be a properly revised plan. Now, a proportionate reassessment is not the same as a full reassessment, and it is horribly within the decision-making power of the legal authority, how far back they have to go. But again, they have to act rationally. And if the change of circumstances is due to a cut in the price or an increase in the price, then they have to have an evidence basis as to what is actually happening. My last few slides before we go into a discussion are really about what's going wrong with direct payments. It's really important to know who is who in direct payments law. There is the service user, there is a nominated helper, or there is an authorized person. And the key thing to understand is that it's a person's capacity that determines whether they can nominate another person or must have an authorized person instead of them holding the direct payment. In both cases, the key thing is that the council has to approve of the nominated helper or authorized person. Some councils have been thinking, I think, that it's okay to say that they don't approve of anyone other than themselves offering a managed direct payment. So that in fact, they are almost indistinguishably going from one function to another. They are commissioning for their commissioned clients 1 minute, and then they're acting as the brokers and the payroll services for people on direct payments. I know, for instance, that Norfolk took back direct payment, so-called management last year. And we know because we have clients that as soon as that happened, there's a conflict of interest between those staff and the people who they're supposed to be acting for. If they are a nominated agent, they are an agent of the client. They are not able to just ask their boss what their boss wants to happen that day. There's lots of law about who can be an authorised person, but we still find councils are not bothering to take the responsibility of making the appointment formal. And that leads to all sorts of fudge and shenanigans in relation to who is the real employer and who is responsible. And the worst trend is this reference to a managed account. A managed account sometimes being called an ISF, and then a managed account sometimes being a direct payment that the council is managing because of the person's so-called choice. Turns out that the person wasn't given a choice. They were told that they had to have the council as manager, as if there wasn't a single other person in the world who could have been appropriately nominated to help the individual manage. So the last couple of questions I just want to focus on so that you can see what you're getting. The biggest question at the moment, I think, for people on a direct payment is, can they expect to be paid as much as the council pays an agency, or can they expect to be paid more for their budget if the agency that they want to use their direct payment on is more expensive? Conversely, if they choose to have an employee, will they be given the same rate as an agency rate, or is there a justification for paying them less, since they, the client, are not in business to make a profit? You can see here that my perspective is to look at the guidance, and the guidance is astonishing. It makes social workers' mouths drop open. It talks about councils deliberately choosing to pay a direct payment client more so that they get a more flexible and a better value service from an agency than they would otherwise get from going through the council. So there's really good stuff here. And I've got these two slides just for the happy bit at the end. So Alan, when you get to this bit, remember that there is a slide that talks about how people working in social care can help clients get and then keep their care packages. I make no apology for saying that it must be knowledge-based as well as skills-based. So that brings me to an end to my talk, and I would now turn over to Alan. Alan, you might want to leave me unmuted, but I hope that you're back in the room and you can shout over my budgerigars.
Linda, that was fabulous. Thank you so much for that presentation. I think we could all listen to you for many hours. I hope we all feel much more motivated and empowered in terms of challenging and fighting injustice. But I want to hand over now to everyone in terms of questions they've got in terms of local examples, experiences, and the challenges and opportunities locally. So using the chat, please, can you put on your questions? I think we have a few on there already. Lucy, I know you've been looking at those questions. So Belinda, just give you a moment to start reading those questions and answer them, because I think really want to make sure we get everyone an opportunity to ask you, as such an expert on this, their questions. So what are the first? So on the chat, I can see a couple of questions. Belinda, are you able to read them and start to respond?
Yeah, I see that the chat involves a lot of genuine just chat and hellos to everybody. I'd like to stress that the slides will be shared, and because I can't go straight from talking and reading the slides.
Okay, Lucy, can I ask you to read the questions out, please, that you've identified?
Can I make another suggestion, Alan? Sorry.
Sure.
I would like people to be thinking and maybe unmuting and talking whilst I'm reading the questions about my two provocative questions. And then that just gives me 2 minutes to read some of the questions, if that's all right with you.
Absolutely. Is that okay?
People could continue to put their thoughts on this, since we're not doing breakout rooms. They could continue to put their thoughts in the chat. My two provocative questions are really, to what extent are your organization's aims and operations the way you operate? To what extent are those things consistent with valuing knowledge as opposed to just skills? Knowledge about law, knowledge about legal principles, and particularly knowledge about remedies that would help you help people enforce a notion of having a right to reasonable social services? And secondly, to what extent can your staff or members reliably access support internally if they want to increase either their own knowledge or service users' knowledge or family carers' knowledge or even providers' knowledge, let alone social workers' knowledge of the legal framework? So that's really asking you to just have a quick individual focus on the balance between knowledge and skills and whether you've got resources that can take you up the learning curve. Because as a charity, we have to sell resources, but we also give an awful lot away. And the question and answers that I provided the links to through to this organization to distribute, it's 100 question and answers about adult social care law. And we did that to raise money, but we also did it to just show that you can answer those questions if you've got a bank of resources. So I'll focus on the, Alan, you could talk if you wanted to, but I'm going to focus on reading the questions now, okay?
Okay, that's fantastic. Open it up though to in response to those two provocative questions that Linda has asked. If anyone wants to open their mic and respond.
So just to add, so those questions are posted right at the top of the chat, so you can review them there. But please, yeah, if anybody would like to offer any observations or share any of their sort of organisational experience, that would be really welcome.
Who's first, please?
Right. Can you still hear me, Alan?
Yes, I can.
Yeah, in fact, most of the chat is not questions. So unless I'm only got one page and I can't see the other questions, most of the chat I can see is not questions. What I can see is that there is a question from Jean saying this: I watched a conference about recording the conversation between the service user and the authority. Is there a place for the service user to be able to use that conversation to ask for a second opinion if they feel they're needed? What do you feel about this? And I'm certainly game to answer that question if you would like.
Please.
Okay. I know from experience that if you go to a meeting at social services and you're going to their building, they don't like you to record them. And they tell you that it's their decision because it's their office, okay? Now, I don't think that they have, as public officers, any right to tell you that you can't record them in the discharge of their adult social services functions. I'm assuming that the meeting is to discuss something in relation to somebody's care or support plan. On the other hand, if you sneakily record them without telling them, in other words, you just take your voice recorder or you stick your phone on and you don't have the gumption to say, I believe I have the legal right to record this. Out of courtesy, I am asking your permission. If you do not give me permission, can you tell me what the source of your legal authority is for not permitting this? If you don't have the gumption to do that and then you try to use a recording, you can expect the ombudsman and the courts not to be impressed at what you were doing. I still can't say that it's illegal, but certainly if you have if you've been transparent, and particularly with Zoom allowing recording, it's good for everybody's protection, just like dash cams and police cameras on police over what's the word, waistcoats, etc., jerkins. It's good for everybody's protection. And if you do record a conversation, of course you can ask for a second opinion. The trouble is that you've got to pay for a second opinion, and experts and lawyers, even lawyers who run charities, are not able efficiently to finance running if they've got to sit through that whole conversation and the ums and the ahs and the muffled bits. So if you're going to use a recording, then I would say use a service that offers you a word-based transcript, because professional people can skim read much faster than they can bear in this very difficult era to listen to the whole conversation all over again. So I hope that that's helpful in that respect. Now, can anybody else see another question that that people want to ask? Okay. Is it going?
Can I ask if anyone's has got examples of their own experiences locally? Want to share them with the rest of us?
I see a new message, but basically, I think that people are not using the chat to ask questions, and that's absolutely fine, in the sense that I did say I didn't want to answer questions about each and every bit of the Care Act journey, because I provided the questions and answers in advance. I think that people are interested in sharing the recording. There's a comment that it's been thought-provoking, and we do in our organization have some work to do. So I think that that is all the acknowledgement that anybody could ask for, that I'm not just hectoring people. I am saying that we're sleepwalking into adult social services not being manageable by the voluntary sector if we don't keep hold of a knowledge base.
The question I got, Belinda, is any advice you can give us how we can better work collectively? Because as individual organizations, we'll fight for our clients, but how can we work more effectively collectively? Because I'm not sure we're doing that sufficiently well. Is there more we could do in Norfolk, do you believe we could do?
I think there is, and it's fantastic that you have about 20 organizations that do kind of occupy a related space, because it means that you can fund something like training with all of you just paying a few quid. One of the bizarre things about COVID is that I've taken 10 years to try to flog training online to local authorities. And either their computer people's service level agreement didn't mean that they could take down the firewall, or this, that, or the other. They wanted to do it with e-learning. You can't teach nuanced stuff with e-learning that is just based on pictures. You know, IKEA instructions are hard enough, but you can't turn adult social services law into pictures. Every answer to every question from a good social worker would genuinely be, well, it depends. And knowing what it depends on is the key legal framework knowledge thing that you would need. So because you can band together to buy training that could be for 100 people, and you do not now have to book a room for 100 people, and you can have the recording, and you could, for instance, put that out there to the public without it being any one organization's fault, as it were. I'm thinking of, you know, punishment from one's funding authority,
yes,
being mouthy. You can do what they do. They hide behind multidisciplinary team decision meetings, so you can hide behind being a collective. I think also that you need to engage with providers of services, hands-on services and care services, because I know it seems odd to think of the rapacious provider sector that we love to think of as being greedy and driving Porsches around. It's funny to think of them as natural advocates, but there is one simple thing that will make you realize that they are the most obvious natural advocates for their clients. Someone's personal budget under the Care Act is the cost to the local authority of meeting the needs. And the cost to the local authority of meeting the needs is the fee that the provider has the guts to charge. So if we don't make providers aware of that, they won't be engaging with the need to protect their service users' personal budgets. They'll be used to being bullied into giving discounts or not asking for increases, and they'll be thinking of all of that as public procurement. But in fact, if the care provider sector keeps on cutting its prices lower and lower and lower, that fee cut provides Norfolk and other councils with the very evidence basis that they need to then put down everybody's personal budget. You need to be a collective to reverse that trend. And the people you need to work with are the actual care providers who don't know any public law at all about how it comes about that their service user has got a personal budget. And I would like, working with Cascada, for instance, in relation to cluing up providers, I'd like that to be a badge of pride that a provider bothers to wear, because then they're saying to their public that we are better providers than each other because some of us have bothered to go up the legal literacy learning curve. And in that way, they would then stop thinning out packages just for fear of competition from a more desperate provider who will go lower and lower and lower. And understanding that link between the private law side of the dirty dealing and the fees and the contracts, and the other side of the clients and the carers' public law rights to a decent, sufficient, transparent personal budget is, I think, that's the space that the voluntary sector can occupy and perhaps collectively enhance.
Absolutely. That race to the bottom, isn't it, always in terms of price, is just taking us downwardly, not what we should be doing. There are some questions now in the chat, I've noticed.
Yes, excellent.
I will either, you can either Belinda read them, or if the individuals opposed to those want to come put on their mics and ask them, please do. Let's make this interactive.
Okay. Does anybody want to do their reading?
Hello, Jackie Cushing here from Community Action Norfolk. Hi, Belinda.
Hi.
Really interesting. I mean, my question was really how in a kind of a situation where quite often clients and VCSE organisations feel that they're in an unequal power relationship with local authorities. How best can they support clients, service users to get their needs considered appropriately? You've talked about knowledge base. So my next bit is, you know, there are limits, as I'm sure you appreciate, in organisations being able to do this individually, as quite often the VCSE sector of smaller organisations. Are you suggesting that collective action is the way forward?
There are some things that, for instance, database providers or online version of, you know, law reports people, there are some things that they will not provide you collectively because they still have to make a living. But I have found that if I join up with another organisation and I ask somebody who's got something that I want, whether they're happy to make it for more than one organisation, some of them will say yes. So just in terms of equipping my own advisors, for instance, Cascada works through contractors. We don't employ anybody. So the contractors are effectively a different business entity to Cascada. But I have found that database providers are willing to let me include my contractors under the auspices of a subscription that I might have. So that helps the knowledge base. I think that the knowledge base makes you feel more powerful. Ever since I started doing this in the early 2000s, my catchphrase as a, you know, care and health law was knowledge is power. And I really find the most gratifying thing is when the light bulb goes on for somebody and they grasp that, in fact, with just a few juicy, ripe words, they can redress the power balance. There's another issue about persuading clients that they even want to, because they are so afraid of reprisals and punishment and aggravation. And that is extremely disdainful in 2020. You know, it shouldn't be like that. I think voluntary organisations, insofar as grant funding is key to your survival, is something that I'm just glad I don't have to deal with. I once went to a conference where somebody came up to me, an advocate, and she said that she'd heard the advocacy organisation's manager on the telephone to a commissioner from the local authority, and the commissioner had actually said, "Could you get your advocates to be a bit less robust, please?" And the manager just fell in because it was time for the renewal of the Care Act advocacy framework. So I think people need to understand their place in the system and to think about how important it is that the voluntary sector remains one that is independent and has integrity and will speak truth to power. And this comes back round again to having the knowledge, not just to shout. I don't believe in shouting loudest, but the knowledge with which to be assertive and politely but confidently, calmly rooted in the legal framework. I think that social workers used to be advocates for their clients, and now they've been dumbed down into being box tickers. And that's why when I train social workers, I try and remind them of why they got into this in the first place. And I think that if you're going to call people professionals, if you're going to call advocacy, brokerage, payroll support and social work, if you're going to call it a profession, then you need to say to people that they must take responsibility for their own continuing professional development and not just sit there and wait passively to be given the training. And that may be harsh news, but I'm afraid that's my position. There's a famous Doles case where the local authority lawyer's excuse for what the council was doing was that she hadn't been given the training yet. And I nearly choked when I read that. That was a local authority lawyer saying that as a professional, she couldn't get her own training sorted out. I find that shocking. So I'm sorry to say that, but that's where I think we're going.
Thank you. Last question, because I'm conscious of time. Emily, do you want to ask your question that I see on the chat?
Yeah, I can do. It was more just a general, just if you could follow up about your opinion about the 3 conversations approach, because they are doing that.
Yes. I am known not to be a fan of 3 conversations, but that is not because I've got anything against the idea of making assessment and care planning conversation based. My predicament is that when I see it in use, pretty much like resource allocation systems were fine in theory, but then messed about with by local authorities, I find that there is no consistency in the way the council have absorbed the point of 3 conversations. And what always happens, or what usually happens, is that the conversations 1, 2, and 3 are never located in the Care Act linear legal process through the progression from outside the front door all the way to review and commissioning a year later. So I can't say that I think that the 3 conversations could not ever be lawful, but the way in which I see it implemented makes me concerned that local authorities are deliberately thinning out assessment, not just because of COVID, but generally, and not telling people where it fits in the Care Act journey, and not telling people that if it doesn't fit in the Care Act journey, then in fact it doesn't decide anything at all, and people are very welcome to insist on their Care Act legal framework, legal rights. My logic is that if a council knew that it had to say that to people, it wouldn't like to say it because it doesn't sound very good. We're doing this on a wing and a prayer, but we know it doesn't count as a legal assessment. So if in fact you'd like a legal assessment, we could do one, but should we just carry on doing this wing and a prayer job whilst we're at it because we're all working very hard? I don't think anybody would accept a 3 conversations model if that was the way it was explained. So I think that there is real danger, particularly because of restitution now being the financial payback for breaching the Care Act. I think there's a real danger that the 3 conversations approach, if not properly located in the Care Act journey, will lead to claims for restitution.
Thank you. Thank you very much. I'm very conscious of time, so I'm just going to say to Belinda, is there any final piece of advice you want to give us, and also just to remind everyone where they can get all the additional information that you very kindly have put together and made available?
Okay.
So, Belinda, anything you finally want to make to the crowd, to the people listening?
Yeah, my one bit of advice would be, don't believe anything you are told at this moment about what a council is doing or is trying to do. I think just as social workers have delusional ideas about what the legal framework says, so do members of the public. People will come to you and say, this has happened, I've been told this, I've been told that, and it will sound as if it's dodgy. But in fact, when you nail the facts, and that is the key thing if you want to help that person get legal advice, when you nail the facts, it will often be that a desperately unhappy social worker has just hinted to the person that there have got to be cuts, and that there hasn't been a cut as yet. So my job as a charity CEO is stymied by the fact that people come to us with incoherent streams of consciousness. And the most useful thing that the voluntary sector could do from our perspective would be to get legally literate enough to know what needs to be probed and what needs to be nailed, and where the client needs to give you some evidence, if there is any evidence, that what they think has happened has actually happened. That would save us the most time and make us more efficient. We do sell packages to the voluntary sector, packages of 3 hours of advice a year, plus webinar recordings, so that you have the means to roll out webinars on the whole of the Care Act to your own staff. Whether you pay them to listen to them, of course, is or not is your business. And that's why I mentioned that they should be professional enough to do it for themselves. But the bottom line is that we have got a database on our website, which has got loads of questions and answers. And I have provided the link via Tasha to 100 questions and answers about adult social care law that we are being asked practically every month. So I hope that those will be passed on along with the recording. And I would just say, what a fantastic opportunity for me to be able to be upbeat, and a bit upbeat at any rate, and passionate about why I do what I do. It's made me get through another week of COVID, and I hope you too. So thank you very much indeed.
Linda, thank you. I want to thank you from behalf of everyone here. I think you've given us that motivation. I think you've given us empowerment. Clearly, information, knowledge is power, and we need to readdress that balance of power that sometimes we get worn down by at times. And I think that motivation to step forward more collectively, I would urge us all to work more collectively together, because I think sometimes that, as you've alluded to, that can give us more power and that shared information, that shared knowledge. So I hope everyone's benefited today. I have immensely. I just wanted to say thank you for your time, the information you've given us, the access to further information. I found this incredibly motivating and empowering, and a kick up my arse, to choose my own language. But you know, sometimes we need it, because you do get worn down sometimes, and that kick sometimes can be what we need. And I don't think any of us have lost the passion, but sometimes we can get worn down. So thank you for that. Appreciate everyone's contribution today. Thank you, Belinda, particularly. And we passed the time, so thank you, everyone. And obviously information will be shared as stated. Copies of the slides and the recordings will be shared by Tasha. So thank you, everyone. Thank you, everyone, for your contribution. Belinda, it's been brilliant. Thank you.
Thank you very much indeed.
Thank you.
Thank you, everyone.